All right, well, let's get started. I think people will continue to join us, but we have a good number right now. Welcome, everyone. Thanks for attending. We even have some from Greece, so it's very early in the morning there. So thank you for joining us. First and foremost, welcome. This is our first estate planning webinar, which is part of our new webinar series. We launched this series last March as the world shut down with COVID. The pandemic challenged us to be more creative in our goal to connect our global community to the school and to each other. We now offer 1 to 2 webinars a month, showcasing experts from our community, and topics explore a wide range of themes from business, career advice, wellness. We have a webinar tomorrow actually on mindfulness, so there'll be details about that later. And connection is important in our community. As you know, next year we'll be celebrating 200 years of Greece's independence. And hopefully you also know that in 5 years, in 2025, we will celebrate 150 years of the American College of Greece. So we want to make sure you're connected to us to help us in this celebration. As the school is approaching its 150th anniversary, the leadership of the school asked how we as an institution, as ACG, could help Greece achieve its best future. The question gave birth to ACG 150, which is a visionary strategic plan that leverages educational programs for economic and social impact. ACG 150 establishes Greece's first Institute for Hellenic Growth and Prosperity. And within this institute, we will house the centers of excellence in areas including tourism and leisure, logistics, shipping and transportation, as well as research, technology, and innovation. Another strategic priority of the school, and a very important priority of the president, is to increase alumni engagement with the school and with each other. We want to stay connected with our alumni, and we do it by these added value activities like the webinar today on estate planning in uncertain times. And soon, when we are back together and able to meet, we will have events all over the world and we can celebrate in person. Before I introduce our expert speaker today, a few guidelines. If you have questions during the webinar, you can raise your Zoom hand and you can write your questions in the Q&A. Our guest and expert, Mr. Darling, will pause throughout the presentation at opportune times to answer your questions. And my colleague who's in Greece right now, Christina, thank you very much. It's very early there, will help drive the webinar and unmute you so you can talk. So let me introduce our speaker. Our attorney, Hyman G. Darling, is a partner in the Western Massachusetts firm of Bacon Wilson PC, where he has practiced since 1981. He is a graduate of Boston University, class of 72. He concentrates in the areas of trusts, estates, taxes, estate planning, probate, guardianship, special needs, and elder law. Prior to joining his firm, he served as a trust officer. Attorney Darling is a past president of the National Academy of Elder Law Attorneys, as well as the Hampden County Estate Planning Council. He has been a frequent presenter for the Massachusetts Bar Association, MCLE, and many Springfield, Massachusetts civic and professional groups, in addition to speaking at numerous conferences. Attorney Darling is a member of the Special Needs Alliance and many local plan giving committees, as well as an adjunct faculty member in the LLM program at Western New England University of Law and Bay Path College. We have a big agenda today, a lot to cover, so I will hand the reins over. Thank you for doing this for us.
My pleasure, thank you, and welcome to everybody wherever you are around the world, especially Christina, who I think it's 2 in the morning there, so thank you. So we have a PowerPoint, and we're going to bring it up here, and this is really for your reading pleasure. You shouldn't have to take too many notes, but don't hesitate to interrupt me as I'm going through this. I'd rather answer the questions as we're going along. We don't have that many attendees, so I'm happy to answer the questions so that there's good continuity within the program. So without that introduction, let me just tell you that what I do is pretty much basically just estate planning and probate work. That's really all I do. If you call me because you want to get divorced or want to file bankruptcy, talk to one of my partners. That's not what I do. I am licensed in Massachusetts only, but this is going to be a pretty generic program of most of the laws that will affect everybody in wherever you happen to live. But I'll throw a couple things in special here about different laws of different states, especially Massachusetts. I would encourage you to ask questions tonight, because if you hire me and call me tomorrow to ask a question, you're going to pay for it. Tonight it's free. So I'll answer all your questions tonight that I possibly can. With that, let's get started. Let's just change the slide. Thank you. So what is the purpose of estate planning? What is the goal of people when they come to me or they want to do an estate plan? Well, you want to provide for your family, make sure that you get as much money to the next generation or somebody as possible. Transfer the complex assets. Sometimes there's a business interest or a limited partnership where you've got property in more than one state. We want to make sure that that gets taken care of easily. You want to avoid probate. In some states, probate is not terribly difficult. In some states, it's expensive, it's time consuming. In my state, you cannot close probate for 1 year from date of death. So if you can avoid it, you definitely want to do that if you can. We want to minimize taxes if we can't eliminate them. And we'll talk about taxes in a little bit more detail in about 15 minutes. Accomplish all your charitable goals. I'm assuming that everybody who's on this call has charity on their mind, or you should. You should want to give to somebody. I would think that everybody gives something to somebody every year, whether it's the American College of Greece or your local church or your library or your hospital or the American Cancer Society. Somebody should be making gifts to everybody. And we'll talk about some of the best ways to do that also. And then there's that all-important goal, which is sometimes a miracle, and that's maintaining the family harmony. I can do what I can for you on that, but it's not up to me to make that decision. All I can do is lead you down the path to make sure that you're thinking of things clearly. For instance, if you just gave your daughter $50,000 to make a deposit on their new home, what are you going to do about the other children? How are we going to equalize that so that there's no hard feelings? Very often somebody says to me, but my child is a doctor and they married a doctor and they've got more money than anybody. They don't really need it. So I'm going to give more money to my other kids. And I say, well, let's think about that, because maybe we don't want to penalize your child because they've done very well. That wouldn't be fair. And they count your dollars just like everybody counts them. We want to make sure that there's not going to be a problem later, because when you're gone, it's your children that have to get along. They can be mad at you about whatever you do, but it's your kids that have to get along. And if they can't work together after you are gone, then it's your fault that you didn't plan properly to make sure that they maintain that family harmony. And one of the things that I was taught a long time ago by one of my professors who was more of a PhD than a law professor is that your children spend more time with their siblings than they do with their children or their parents over their lifetime, because they have a longer life together than just with either their kids or with their parents. So they've got to spend a lot of time together, and then we get in-laws involved, and sometimes we call the in-laws the outlaws. But we try to make sure that that works for everybody. So that's pretty much the goal. So let's talk about the documents that we want to use within the plan. And there are some basic documents. The first is a will, and then there's a power of attorney and a power of attorney for healthcare or an advance directive. Then we get into more sophisticated planning documents, which I'm going to talk about in a second. But let's stay with the basics. The two most important documents I think that you could have in your plan are the power of attorney and the health proxy or advance directive. And we're going to get into that in a second. But the reason is because these are important for you while you're alive. The will comes in after you die. I'm concerned more about my clients while they're alive to make sure that they have the right planning and process for them in case they become disabled or incapacitated mentally or physically. And the will is, after you're gone, the will comes into being and we'll probate the will and things will just happen. If you have a larger estate, you might want to do some advanced planning, and that would be the use of trusts. And trusts are used for a lot of different reasons. A revocable trust can be used to minimize taxes. It can be used to avoid probate. And if it's an irrevocable trust, it can be used for the purpose of providing for long-term care expenses, so that a person would not have to spend their money on long-term care. But if you do that, you usually, in most states, have a 5-year waiting period. Any transfers that you make to a child or to an irrevocable trust is subject to a 5-year look back. So if you start giving all your money away to your kids, they better keep that money, because if they spend the money, what's going to happen? Well, if they spend the money and then you go to a nursing home within 5 years and they have spent that money, you're going to be kicked out of the nursing home, because they won't take you because you don't qualify for Medicaid. So I've got some props. So if you happen to do that and the kids spend the money, they basically put you behind the 8 ball, because you no longer have that money and you're in a disqualification period. So you're really on your own, and you have a fate worse than death. You have to live with your children. And those of you who are listening to this who are younger, your parents will have to come in and move into your house. So think about that before you spend the money. Complex trusts, if somebody has a family member who is disabled, we might want to have a special needs trust. Unfortunately, I see all too often parents coming in these days with children who have disabilities, and we have to plan for them so they won't lose their governmental benefits. Very often they also have children who are they're on drugs, they're alcohol dependent, they've got gambling addictions, they've got major problems. They're in debt, or they're ready to file bankruptcy. Well, we don't want to leave these kids money outright, because it's just going to be taken by their creditors. So we want to set up a trust to preserve that money and protect the money from the children and the children from the money. So there's lots of things we can do, and there's lots of planning for taxes, and we'll get into the generation skipping tax and the marital deduction planning in a few slides from now. But let's move on now to the planning techniques that I think are the most important. In the advance directive. Now, this is a document that in some states call it a living will, some call it a most or a post form, a physician's order for life-sustaining treatment. Come back one. There we go. Okay, life-sustaining treatment. We might want to have, some people call it, in my state, we call it a healthcare proxy. Different states call it different things. This document says who's going to make your medical decisions if you become incapacitated mentally or physically, and you can't take care of things. Now, you could be disabled physically and fine psychologically. In that case, you can make your own decisions because you're competent to make your own decision, but physically you might not be able to. But that's okay, because you can tell somebody what you want. It's important to name a person to make these decisions. If you don't name somebody, then who's going to make those decisions for you? Well, you've probably heard about some of the famous cases in the US. Nancy Grizon, Karen Quinlan, Terry Schiavo, all these famous cases where someone had to go to court and get appointed by the judge to make a decision and to carry out someone's decisions because they didn't have a written document. Those cases went on for years. People were kept alive by machines for years. It cost thousands and thousands, hundreds of thousands of dollars to litigate each of these cases. And each one could have been avoided by a person having a simple advance directive document that said that they didn't want to be kept alive by machines. So a lot of my clients are asking me now, gee, I've got this advance directive. It says I don't want to be kept alive by machines, but what if, God forbid, I get COVID? Do I want to be on a respirator? This document says I don't want to be kept alive by machines. And the answer is not to worry. Most of the documents say that you don't want to be kept alive by machines unless you're going to have a chance of getting better with a quality of life. So if you have COVID and you're going to be put on a machine, you're going to be on that machine as long as you can probably get better. At some point when it looks like you're not going to get better, then maybe you'll be taken off the machine. But that's going to be for someone else to decide. And it's not the doctors that decide that. It's the person you nominate to be in charge. So if you're married, you probably name your spouse, but you always have to have a backup, because you could be in an accident, your spouse could be deceased, and you could be incapacitated. And if you don't have a backup, then the document is worthless. So we need to always have a backup. If you have children that are of legal age, maybe you name them. If they're 18 to 25, maybe you don't want to name them because you don't want to burden them with that. So you name one of your siblings or a good friend to be in charge of making those decisions. I always say also in this document, you should specify whether or not you want to be buried or cremated. And if you're going to be buried, where, if you have a place. If you want to be cremated, fine, but are you going to have your cremains buried, or are you going to have them scattered in the Aegean Sea? I don't know, but somebody should make that decision, and you should let your family know. And those of you who are younger on this call, if you don't know what your parents and grandparents want, you need to ask them what they want, because if not, it's going to be a big problem if and when something happens, especially if it's a second marriage. If it's a second marriage, in many states, the spouse has control of the body when someone dies, and therefore they control. So I always tell my clients, if they're older, go and pre-plan your funeral, make the arrangements, and then it's done. And no one has any guesswork about what's going to happen. The children of the first marriage aren't going to argue with the second spouse. It's going to be hopefully a seamless transaction, especially after the client is gone, because the client sometimes is the glue that holds the family together. But when they're gone, sometimes things fall apart. So we don't want that to happen. We want to have this plan foolproof so there wouldn't be a problem. If you want to be an organ donor or donate your body to science, that should be in your document. It probably is on your license also, but it should be in this document so that everybody knows what you want or what you don't want. So it's very important to have all this language in your advance directive. If it's in your will, that's great, but after you're deceased, or as I say, when you hit room temperature, and somebody reads the will, by then it's too late. Organ donations have to be done pretty soon right after. So it's important that everybody knows what you want and when you want those things to be done. Now, similar to the advance directive, we have a document called a power of attorney. Next slide, please. And the durable power of attorney is durable, which means it extends into your incapacity. If you have a regular power of attorney and you become incapacitated, the power of attorney terminates. So you always want to have a durable power that extends into your incapacity. And it has to have some magic words in it, like this document shall be extended into my incapacity, or if I'm incompetent, this document shall not be terminated. Every state has different rules about what it should say, but it's very easy to put that in that document. And this is just like the health proxy, only this is for financial decisions. Who's going to pay your bills? Who's going to file your tax return? Who's going to take your required distribution from your plan? Who's going to continue to make your annual gift to the American College that you make every year? Who's going to do that if you become incapacitated? That's going to be your power of attorney. And we call that person an agent under the durable power of attorney. And everybody should have this document. Once you hit 18, you should all have a health proxy and a power of attorney. In fact, if you have children who are off going to college, you might want to have them have a health proxy, because if they're in college and they get ill, and the people if they're in college and they're really there, somebody has to make the decision about what's going to happen if they're incapacitated. And under the HIPAA law, nobody can disclose information. So you need to have your kids give you the authority to discuss these things with the person at the infirmary or at the college campus health center, so that they know what to happen. Now, sometimes your children don't want to do that because they don't want you to know what medication they're taking or what's happening in their lives. So there's a fine line sometimes about what's shared and what's not shared. In this document, it also states who's going to be the backup. Who's going to be the backup? If you name your spouse and your spouse is deceased and you don't have a backup, again, the document is not worth what it's printed on. So you want to have that in there, whether it's a family, friend, cousin, niece, nephew, child, whomever, you want to have somebody do it. Again, I don't think that a child who's under 21 probably is responsible enough to do it, but I won't make that decision about your children. I'll let you decide that. If you don't have this power of attorney, then what happens is when you become incapacitated, your family has to hire a lawyer and go to court and appoint someone to be the conservator. The conservator is the person who's going to be in charge of the finances. It's a public proceeding. All your assets are then public in the court. The lawyer is going to take a big fee to do this. They have to be bonded. You got to buy a surety bond. It's a whole big deal. All of this can be avoided by a simple power of attorney. In some states, you have to have what we call self-dealing powers. So let's pick on Allison. Let's say, Allison, I don't know, but are you married?
Yes.
Yes. Okay. So we'll pick on your husband. Now let's say he becomes incompetent and you own a house together and you want to sell this house and move. In some states, if you don't have specific authority under the power of attorney to deed the house to yourself, then you can't. You have to go to court and get a conservatorship. If you have the power in there, you can deed the property to you. You can sell it. You don't have to get anybody's permission. You don't have to account for the money. You just do what you want to do. But in some states, you have to have special self-dealing powers. I already said that you have a backup. If you do move to another jurisdiction, if you're in Massachusetts, and I don't know why you would want to, but you move to Minnesota, you want to have your document updated, because while Minnesota still recognizes Massachusetts document, there might be something special about Minnesota law that you want to include in that document. You might also have a child that you name to be in charge, and your child has moved to California, and you love your child, and they're great kids. But let's say that you named your child 5 years ago when your child was single. Your child is now married, and you really don't like the person your child married, and you think that your child possibly could be unduly influenced to do something wrong by their spouse. Remember, I talked about the in-law that's now an outlaw? That's what we're talking about here. So if you don't think that your child can step up to the plate and stand up to their spouse, if they tell them to do the wrong thing, then you shouldn't name your child. It's time to revise that document. Maybe you put somebody else in. Maybe you name 2 people to serve together. And that takes the guesswork out of allowing just one person to do it. There's lots of extra powers that we have. My power of attorney goes on for about 8 pages now. I give the power to make gifts, to make charitable gifts, to file a tax return, to take care of the pets, to sell the guns, to deal with Bitcoin. I mean, all these things that we didn't used to have. I have special language in my document for that. To change the post office box, to enter a safe deposit box, to change life insurance, you name it. This person is going to step into your shoes to make your financial decisions. Okay? Any questions about health proxies and powers of attorney? I don't see any questions, but I hope they're all paying attention, because we have a test at the end of this, don't we? A little quiz. They're all in school, so that's what this is about. Okay, let's move on to wills and trusts. The wills and the trust take care of you after you're deceased. The power of attorney health care are while you're alive. So this is really going to be a little bit easier, because you're going to specify who's going to get your assets if and when you pass away. It's going to cover your tangible property, your real estate, your business, your stocks and bonds. You only probate an asset if it's in your name alone. I'm going to repeat that. You only probate an asset under your will that's in your name alone. So we're going to pick on Allison again. She has life insurance. I'm guessing she names her husband to be her life insurance beneficiary. Her retirement plan probably names her spouse to be the beneficiary. Her bank account might be joint with her spouse. Her house is probably joint with her spouse. All of those assets are not in her name alone. None of them go through probate. If she passes away, they automatically pass to her husband. They do not go through probate. Okay? Probate is only what's in your name alone. So those of you who are single, or if you're married and you still have assets in your name alone, those assets will pass through your probate, through your will. They will have to be probated. So what does your will say? Well, it's going to say, I leave all my assets to my spouse, if not to my spouse, then to my kids in equal shares. And if a child isn't living, his or her share will pass to his or her children, right? We want it to go to your children's children, not to your children's spouse. If it goes to if your child is deceased and it goes to their spouse, that spouse could get remarried and all of a sudden the money is out of the family. Because if that spouse remarries and leaves it to their new spouse, then your grandkids never get the money. So we don't like to do that in too often. Sometimes the client says, I love my in-law more than I love my child. Well, that's great, but we don't know what's going to happen. Who's going to be in charge of the estate if something happens to you? In some states, we call that person an executor. Some states, we call that person a personal representative. So who's going to be in charge? Well, probably your spouse. If not your spouse, maybe your child. If not, maybe your brother or sister, maybe a lawyer, maybe your banker. I don't know who you're going to name, but that person should be trustworthy and responsible. We want to make sure that that person has the best interest of your heirs at heart and will do the right thing and won't just take that money and sell something just to sell it, that they're going to get the best price for whatever they can do, and they'll do the right thing to save on taxes. If you're young enough, you need to have someone to be in charge of your children as a guardian, a legal guardian. In most of your states, it's age 18. Once they turn 18, they no longer need a guardian. Now, we all know that our children need somebody to guide them even past the age of 18, but they are supposedly emancipated at the age of 18, so they don't need a legal guardian. They might need someone, however, to be in charge of the money. And I would think that maybe you name your spouse to be in charge of your children, but you're probably leaving all your assets to your spouse, so we don't need to have a trust for the benefit of a minor child. But in the event that you and your spouse are deceased, then we need a guardian for the children, and we need a trustee to hold the money for your children. The trustee does not have to be the same person as the guardian. It can be, but it doesn't have to be. So if anybody is listening and they happen to be divorced, I would say that maybe you want your ex-spouse to be the guardian of the children, but you probably don't want that ex-spouse to be in charge of the money, because that might be one of the reasons why you got divorced. So you have to be very careful of who you're naming. You've got to think that through. I see that someone's wants to ask a question. I don't know, can you unmute that person that wants to ask a question? Or...
I was just testing the question. This is Allison.
Oh, okay.
So I hope people can ask if they're raising their hands, because I just tried to ask. But anyway, I do have a question though.
Okay, sure.
So what if your children don't get along? This isn't me, and mine are young, but like, what if you get in a situation where later in life you have two, because of the election, one voted for Trump and one voted for Biden, and now they don't speak. So how do you, but one is the executor of your state, like how do you make sure that they'll be fair to each other? What do you do in a situation like that?
Well, you probably don't leave anything to the child who voted for the wrong party. Whoever that is. What you probably would do in that case, you probably wouldn't name the children to serve together, and you probably wouldn't name one to be in charge. You probably go outside the family, name an independent third party until someday the kids could get their act together. Because no matter who you put in charge, it's going to be a problem. There's going to be a will contest, there's going to be a fight, someone's going to object, and you might put language in the wills that says, if anybody objects to this will, they forfeit their share that they would get from my estate. It's called a no contest clause. That will stop them in their tracks from contesting. But in that case, I probably wouldn't name either one of the children to be involved. I'd probably name either a brother, a sister, a cousin, maybe a trust company, somebody independent to be in charge of the estate. That's unfortunate, but that does happen a lot over lots of things. I've got clients who can't have their kids in the same room. I've had people who've died, we've had to have two separate wakes because two factions of the family couldn't agree. They just couldn't be in the same room together. Just terrible situations. Okay, so do you need a trust? Well, nobody needs a trust, but somebody should want a trust. And the benefit of the trust would be to save on taxes. And the next slide, we're not going to get to yet, we'll talk about taxes, but you might have a child who's young enough that shouldn't get their money at age 18 or 21. So I would say that you might have a trust for those minor children or grandchildren where you dole the money out to them. Maybe a third at 21, a third at 25, and a third at 30. I had a client recently who came to me who had a lot of money, $2 million. I think that's a lot of money. And they have one child who's not very responsible. She's 25 and she's not found herself. She's still working a part-time job. Never made it through college, and she just hasn't found herself, hasn't landed yet. So we decided that she should not get much money when she's young. So we're giving her 5% of the money at the age of 25, 10% at 30, and on up until she's 50 years old, at which time she gets the balance. If she matures in the meantime, we can make changes. The trustee has the discretion to use the money for this child's comfort, maintenance, support, education, buy a car, buy a house, go back to school, whatever. The trustee has the discretion to spend all the money on that child if necessary. But the child will not get lump sums, big lump sums, except at certain intervals. I call that hitting the lottery. They're not going to get a big lump sum except, 5%. Well, 5% of $2 million is still $100,000. That's a lot of money. But we have to give this money at some point. But the trustee has discretion to see that if this child doesn't spend the money wisely from the ages of 25 to 30, and the money is all gone with nothing to show for it, then the next distribution does not have to be made. So we put lots of safeguards in here to make sure that the money is just not going to be dissipated with nothing to show for it. The clients work too hard for it. So that's what they want to do. There's no right or wrong ages or percentages. You can do whatever you feel is appropriate. I really, in my documents, I had my kids getting their money at 21, 25, and 30. When my son turned 25, I said, oh my goodness, if my wife and I die, he's going to get 2/3 of his money at the age of 25 because he got 1/3 at 21, 1/3 at 25. I said, that's no good. So I bumped the ages up to 25, 30, and 35. I'm proud to say all the kids are now over 35, and they're not all as responsible as I would like them to be, but I've cut the purse strings, and if something happens to myself and my wife, they get the money outright. And when you divide it among 3 kids, no one's going to be able to stop working. They still have to work. They'll be able to maybe pay off their mortgages, and that's about it, but that's up to them. Okay. Very important, who's going to serve as the trustee? I don't know. You've got to tell me who's going to be the most responsible person to be the trustee. Can be the same person as the power of attorney, same person as the executor. Doesn't have to be, but it can be. It's just taking off one hat and putting on another one. Okay. I do have on here, as you can see, we have special trusts now. If you have a pet, we can have a pet trust. If you have guns, we can have a gun trust. Lots of different things that we never used to have before. The most famous pet trust is Mrs. Helmsley from New York, left $12 million in trust for her dog Trouble. And the judge said that was too much money. And the judge cut it way back to only a couple $1 million. We had a case here in Massachusetts where someone left money in trust for the pet, and they had a trustee for the pet, and they had a caregiver for the pet. And as long as the pet was alive, these 2 people were getting money. Well, unbeknownst to us, the pet died. And they attempted to replace the pet with another one that looked just like the one who died, just so they could keep taking care of this pet. Well, they got caught, and the trust terminated, and the money went to charity. But interesting what people will do for money. I thought that was pretty creative, but illegal. Okay, let's talk about taxes. The exemption for estate taxes federally is $11.58 million. So if you have that much money, you need to be making sure that you're talking to a good financial planner, good estate planning lawyer, and good accountant that can guide you through the process of minimizing the estate tax. Because if you have greater than that amount and you don't do anything about it, and it goes to your family, you're going to your money is going to be paying the government 40% of everything above 11.58 million. Next year, that 11.58 becomes 11.7 million, but it's still a flat 40%. That's on money you've already paid income tax on. So if you have that kind of money, you should be doing some major planning. If you happen to be married, you and your spouse have an exemption of double that. You have a $23 million exemption that you can leave to your family without paying any federal estate tax. This is in addition to what you might be leaving to charity. Any money you leave to charity doesn't count towards this. So if you leave $1 million to the American College, it goes to the American College of Greece, and they get that $1 million, and your estate gets a $1 million exemption for giving that gift. So it doesn't even eat into your exemption because you still have this exemption in addition to what you give to charity. This number of 11.58, which goes to 11.7 next year, at the end of 2025, if they don't change the law, this exemption will go back to $5 million, adjusted for inflation as of 2010, which in my calculation would be about $6 million. That will happen if they don't change the law. Mr. Biden says the rich have too much money, and maybe this exemption of 11.58 should go down to something like $5 million or $3.5 million. You need to pay attention to this because the law is going to change. It probably won't change this year. In fact, it won't for sure. I don't know if it'll happen next year. But if you have this kind of money and you want to save on taxes, you should be doing something very creative, like putting money in charitable trust or giving money to your children before the law changes. Now, 12 states plus the District of Columbia have no state estate tax. Many states have an estate tax. For instance, in Massachusetts, we have a $1 million exemption. But once you grow above $1 million, the exemption of $1 million disappears and you pay tax on everything back to the first dollar. I call that a cliff tax. New York has the same thing. You have a big exemption of over $5 million, but once you exceed that, then you pay tax on everything. Other states might have a $5 million exemption, so the first $5 million is exempted, and you only pay tax on everything above that.
Excuse me, Mr. Darling.
Sure.
We have a question from Mr. Alex Eleftheriadis, and he's asking, what about Florida?
Oh, Florida. Florida is a wonderful place to live, and it's a wonderful place to die. No income tax in Florida and no estate tax in Florida at all. So if you're sick and you're not looking too good and you're on your way out and you have a lot of money, you want to quickly move to Florida, become a Florida resident so that you can die in Florida and save on the estate tax. Now, I kind of joke about that, but you really need to consider that. But you have to do a lot of things before you die. You've got to vote in Florida, which means you have to learn how to vote again because they vote differently there. You need to get a driver's license. You need to have a doctor there. You need to have a residence there. You need to file your tax returns out of Florida. You have to do all these things to make yourself a Florida resident, or otherwise it will not work. So be very careful if you're going to change your domicile. And we can have that discussion another day if you want. But Florida, if you're there already, boy, you're already a home run. You've saved your kids a lot of money. You might have a federal estate tax, but you're not going to have a Florida estate tax. Okay? All the states have different rules. You have to take a look and see what the rules are in your jurisdiction. I have a chart that tells me what the rules in every state, but we don't have time to go through all of those tonight. I'm already behind. So let's move on to the next slide. How can we reduce some taxes? Well, gifting is a great way to make a gift. So let's say, I know Jonathan's on this call. I don't know. Let's say Jonathan has 3 children. How much money can Jonathan give to his children without paying any tax? Now, this is a trick question because you all think you can give away $15,000 and that's it. Well, you can give away $15,000 without any tax, and his kids pay no tax, and Jonathan pays no tax. But if Jonathan wants to give away more money, he can give it away. Because remember on the prior slide, the exemption was $11.58 million. That's an exemption you can give away during lifetime or at death or a combination of both. So Jonathan can give away $11.58 million without paying any tax. And the kids get that money and they don't pay any tax. It's just free money. So what's the consequence if Jonathan gives his child, one child, $115,000? Their first $15,000 is exempt, but Jonathan has to file a gift tax return. He says, hey, IRS, I made a gift of $115,000 to my child. They say, okay, thank you. The first $15,000 is exempt. The next $100,000 basically just eats into your credit of $11.58 million. So when you die, your exemption is now $11.48 million. Who cares, right? Most people are never going to pay an estate tax. So, but it's a reporting requirement, but it really doesn't matter. So don't be limited to the $15,000. In fact, if you start talking to your children about gifting, do you know what they see? They look at you differently. And this is what they're going to see. Okay, they see the dollar sign. They love it when you make gifts, because if you make a gift, they say, thank you, mom and dad. I'll see you again next year. But giving money is a good thing. It reduces your estate for tax purposes, and it gives them some money that they can use now. And it gives them the opportunity to say thank you while you're alive, because once you're gone, I don't think you're going to hear the thank yous. You can also test them by giving them money and see what they do with it. See if they're good stewards of the money. And if they're not, then maybe the next year you don't give as much money, or then you revise your will and tie that money up for a longer period of time. If you have grandchildren, 529 plans are great. They're the best thing since sliced bread, because you can give away money and it's still subject to the same $15,000 exclusion, no income tax, but the money in a 529 plan escapes income taxes. It grows income tax free as long as the money is used for college. So those of you who have children, you should tell your parents and your in-laws and your grandparents to put money in the 529 plan for your kids. If you have children, you should do it. And if you're a child going to college, it's probably too late for them to put the money in because you're already out of school. Now, if you're going to stay in college and get your bachelor's and your master's and your doctorate, they can still put money in and it can accumulate, and you can still take that money out tax-free to be used for your college. I'm just going to ask, does anybody from the Office of Advancement or there know if you've ever seen money come to you from a 529 plan? Maybe not.
I don't know if we've ever been gifted from a 529.
Okay, no, you wouldn't be gifted. The child would be taking the money out, or the parent would take it out of the 529 and give it to you. You might not even know it comes from a 529 plan.
Yeah, we wouldn't know that.
Okay, just wondered.
Yeah.
Okay. If you have a business, giving away shares of a business or a partnership are great, because you can give away shares and you can still control the company, but you can give away little bits of it so that somebody gets some of the income. Life insurance. Life insurance is an asset that is taxable as an asset of your estate. So if you have a life insurance policy and you name the children to be the beneficiaries, if you own that policy, it's includable in your estate at the date of death value, even though the kids get the money. So they get it. It's not a probate asset because it passed to them by contract, but because you own the policy, it is includable in your estate as a taxable asset. If you're not anywhere near the $15 million number or the $11 million number, who cares? But if you're in a state that has an estate tax, you might want to get rid of your life insurance. I don't own any life insurance on my life. Either a trust owns it or my kids own it, because I don't want it to be taxed. I'm not going to take the life insurance with me when I die, so I don't care about owning it. That's the one thing I don't ever care about owning. So you should probably not own your life insurance. Charitable gifts, great planning techniques to use during your lifetime. There's lots of opportunities. I'm going to just throw a couple at you. Remember how I said, if you die and you leave $1 million to the American college, you get a tax deduction against your estate. But if you gave that $1 million into some type of a trust during your lifetime, either a gift annuity or a charitable remainder trust or an annuity trust, one of the types of trusts that benefits the charity, and it provides money for your children or grandchildren during your lifetime, you get an income tax deduction now for making that gift. You get an income tax deduction, and when you die, you also get an estate tax deduction because you didn't own it. So you can reduce your estate for estate tax purposes, but it's the income tax deduction that's a real benefit of giving money away. And there's lots and lots of ways to give it away. And I'm sure that the Advancement Office has all of the techniques available. If not, they know how to get these done for you. One of my favorite things to do, and I think there's a couple people on this program that are at least 70 and a half. In prior years and next year, not this year, you have to take a required minimum distribution, which we call an RMD. And it's based on your age every year. The older you get, the higher amount that you have to take out. And that amount is taxable to you. But if you're 70 and a half, you can say, instead of taking my minimum distribution this year of $5,000, I'm going to have my trustee of my retirement plan or the custodian give that money to the American College. And therefore, the American College of Greece gets that $5,000 and it doesn't come to you. So it satisfies your required distribution, but it doesn't get recorded on your income tax return. And most people who are over 70 and a half don't have a mortgage and they don't itemize the taxes anymore. If you're not itemizing your taxes, then it's a lost deduction for charity because you can't write that off. So this way, if you have it go to the charity, you don't get to write it off, but you weren't going to anyway, but now it doesn't count as taxable income to you. And this is just a home run. Let's say your required distribution is $5,000 and you want to give $1,000 to the American College of Greece. So you can have $4,000 come to you, you pay tax on it, $1 million goes to the American College. They don't pay tax on it because they're 501c3 exempt. That's the Internal Revenue Code section of exempt status. The $1,000 they get, they don't pay tax on, and you don't pay tax on it either. So if you're not itemizing your taxes, then you shouldn't be taking money out of your IRA and then making a charitable gift. Have it go directly from the custodian of your retirement plan directly to the charity. And you don't have to have it all go to one charity. You can split it up among many charities, as long as the American College of Greece gets their fair share, or more than their fair share. Allison's smiling. Okay. But there's lots of things like that that you can do. Lots of techniques. And, you know, I'm not so smart that I created these laws. The government writes this stuff. I'm just a messenger to interpret it for you. So let me do it. I mean, but you know what it is? When you give away money and it's not taxable, you know what that is? I call that's magic. Okay? I just wave my magic wand and I make that tax disappear. Okay, because it's so simple. It's so easy to do. You just have to have the right planning. And, you know, some people don't get the planning advice. You need to get that advice from your accountant or your lawyer because people don't tell you those things. Sometimes you have to ask. And that's why you're here tonight learning these things. Okay, let's move on. I've got, I have another hour left. Is that what the time frame is now? At least 10 minutes, right? So let's go
10 more minutes.
10 more. Okay, let's go on the Secure Act, a fairly new law that was passed this year that allows you not to have to take your required distribution until you're 72. Used to be 70 and a half. Now it's 72. So if you're 71 and you're not taking your distribution, you don't have to. You don't have to take it until you're 72. But if you don't have much other income and you're not paying any taxes, you should take out some money from your retirement plan and make it non-taxable. Just take out enough that doesn't put you into a taxable bracket. There's no reason not to. You should take money out. Now, if it's a Roth IRA, it's not taxable anyway. But if you have money in a 401k or an IRA rollover that's not a Roth, and you've got to start taking your required minimum distributions when you're 72, if you don't have taxable income, take some of it now. You've got until the end of the year to take it. Talk to your accountant and say, how much money can I take out of this plan without paying taxes? Because if you wait till you're 72, you're going to be 2 years older, and then you got to take more out because you're older, so your life expectancy is smaller, so you're going to take more money out. So maybe you should take out a little bit now and reduce what's in your plan. You can still take the money and reinvest it, but it's still tax-free, or you can give it away. You should take a look at that and see. And if you're 70 and a half and you're still making distributions, even if you're not 72, you can still take money out if you're 70 and a half and give it to charity. It's a wash. It's non-taxable. If you are 70 and a half and you're still working, you can still make contributions to your retirement plan. You couldn't before, but now you can do that past 70 and a half. The government's allowing you to put more money in. If you have a birth or an adoption of a child, you couldn't take out money without paying a penalty, and the penalty was 10%. Now they will waive the penalty, but it still might be taxable income to take the money out of your retirement plan. I try to advise my clients, don't ever, ever, ever touch your retirement plan. That's for retirement. Pretend you can't access it, because you're going to need that money when you retire, especially if you're young, because I don't know what Social Security is going to look like when you're older. When I was younger, I couldn't wait till I was 65 to get Social Security. Then they bumped the age up. Now it's like 67 and a half for people who are younger now. And I would be surprised to see it to be 68 or 70 by the time you retire, because they've got to shore up the system to have more money going into it. Distributions. If you passed away, your beneficiary could take the money out of the retirement plan based on their life expectancy. And if they were young, they could take it out of their life expectancy, which could have been 30 years. No more. It's now a 10-year limitation. 10-year limitation. So if you die, your spouse can take that money out and roll it over. But if it goes to your kids, it's going to be paid out to them over 10 years. They can take it, some of it at 10% a year for 10 years. They can take it all in the 10th year, but they have to take all the money out within 10 years. If you have a disabled child, there's a special rule about that. You can put that money into a trust and they're not subject to the same 10-year rule. If you name a beneficiary, please make sure that you update your beneficiary designations. If you name your spouse, then your kids, that's great. Take a look at it from time to time. If you change custodians, if you go from Merrill Lynch to UBS, take a look at it because they lose the paperwork. You should change your beneficiaries and do new forms when you move your fund from one bank or one financial institution to another. Always change them. If you get divorced, please change your forms. If you don't change your beneficiary and you have your spouse named and you die, your former spouse is going to get that money. That's a federal law. Okay, so you want to change that beneficiary. The day you get divorced, you change your beneficiary to your kids or to a trust for your kids or somebody else, but take your spouse off there unless the judge says that you have to keep your spouse on there for a certain amount of money. Okay, review this all the time with your lawyer, CPA, and your financial advisor. Make sure the beneficiaries are done correctly. Another change this year under the Secure Act. If you have a 529 plan and you graduated and you didn't use all that money because you got scholarships or you just didn't use the money because there was too much money in that plan, you can take out up to $10,000 to pay down your student loan without it being taxable. So these are really the benefits. There's some detriments too, but these are the highlights of the benefits of the Secure Act. Last but not least, we have the CARES Act. And the CARES Act allows you to do some things also, which you couldn't do before. The first is that you can take a charitable deduction, which we call above the line. If you don't itemize your taxes, you can take a $300 deduction if you make a gift to charity, but it's not your clothes. It's not used anything. It has to be cash that you give to charity. So if you give money to charity, you get a you get a $300 deduction even if you don't itemize. That's the most you can get. You're also not limited to the charitable deduction, which used to be up to 50%. It's now 100%. So if you gave $100,000 away a couple years ago, you were limited to 60% of the 100,000 as what you could write off. Now it's 100%. You give $100,000 away, you get a $100,000 charitable deduction on your income tax return. However, think about it. If you only made $60,000 this year, don't give away $100,000. Give away $60,000 this year. Otherwise, you waste the $40,000 deduction. Give the $40,000 on January 1st of next year, so you can use it again next year. Now, you can carry over things, but I don't like to do that. It gets confusing. So just give away what your income is so you can reduce your income tax to zero. Because no matter what you give away, if you give away more than you made, Uncle Sam doesn't give you money back. You only get back what you put in for charitable deductions. As I said, the RMD is waived for the IRA this year. But if you did take out money this year and all of a sudden it went down, you can put your money back into the plan, okay? Because the plan was lower. So if you took it out when the plan was lower before the money went back up in value, you can put the money back in your plan. If you had COVID in your family, you can take a penalty-free withdrawal up to $100,000. So if you're under 70 and a half, I'm sorry, if you're under 59 and a half, there would otherwise be a penalty. But if you had a COVID-related withdrawal, you can take up to $100,000 out of your plan without paying any penalty. You still have to pay the taxes on the income, but there is no penalty for taking the money out. I don't like borrowing money from your plan, but the increase in the loan amount from the plan is allowable. You can borrow more, but your plan has to allow it. If your plan does not allow it, it's kind of late to go to your employer and say, would you amend my plan so I can borrow money from my share of the plan? It's kind of late now because it's already November and they've got to get this approved and get it done. It probably will not happen this year, but if you can borrow, you're allowed to. If you borrow money from your plan and you can't pay it back and you're under 59 and a half, it will be taxable income to you and you will have a 10% penalty. So if you borrow 10%, $10,000 from your plan, and you're supposed to pay it back and you can't pay it back because you're out of work or whatever, the $10,000 is not only taxable to you, but you're going to pay a $1,500 penalty because you're under 59 and a half and you didn't pay the money back into your plan. So don't ever, ever, ever borrow what you can't pay back. I tell people get a home equity loan, borrow from family, but leave your plan alone, because if you can't pay it back, it's a big hit that you have to pay later. And you probably want to know what's going to happen in the future with the tax laws and what's going to happen with this year. Does anybody have that question that you want to know what's going to happen with tax rates and tax laws? Well, of course, I have that answer too. Can you see my crystal ball? We can look into this for you, but it's an extra fee. But I keep this on my desk for when people ask me the ridiculous questions that we just don't have an answer to, like, what's the tax law going to be next year? I don't know. I can guess, but I really don't know. Please don't forget that $100,000 annual contribution from the IRA to the charity. That's the maximum you can give. There's no minimum, but it's $100,000 a year. So if you find out that your parents and grandparents or people are giving money, $100,000 could go tax-free to a charity, and it doesn't come into their tax return as taxable income. It's a wonderful opportunity. With that, I'm at exactly 8 o'clock. I'm happy to stay on and answer questions or give you more bad jokes, or whatever you would like.
Yeah, are there any questions? Looks like there's one.
Got a question?
One thing, I don't see a question right now, but one thing I would say is the point you made about the trust is really important, I think, because we have a wide range of ages on this call. Often in the United States, people start saving money for their kids when they're born, you know, in UGMAs or in 529s, et cetera. So, you know, that idea of putting it in a trust, even when, you know, when they're 5 months old, we think they're all gonna be darlings and they turn 18. And to your point, they don't all, you know, you're often looking at them like, holy cow, a lot of states require that they get that money at 18. So that, I think that's a good point too about the trusts.
And you know, once you have these documents, it's easy to amend them. It's easy to change them. Once you do the planning and you get it started, it's easy to call up the lawyer and say, listen, can you do this and do that for me? Just change the trustee or change the beneficiary, change the ages. You don't even need an in-person appointment. You don't even need a Zoom meeting. You can send me an email or send your lawyer an email and say, change this. We might want to talk to you, but it's very easy to change things once you have something in place.
Yeah.
I want to know, I have a question. I want to know who Olga is that's so special. Everyone's saying hi to Olga.
Let's see. So there's a question from Martha. What if you own a house and you have 3 children and 8 grandchildren? Wow, congratulations.
Okay, if you own a house and you have 3 children and 8 grandchildren, it all depends. I don't know what your plans are. In most cases, I would probably say you would just leave that property to your children in your will or in your trust. And if a child isn't living, then his or her share will pass down to his or her kids. However, you could say, you might really want to take care of the grandchildren and say, I direct that upon my death, my house be sold. And I want $10,000 to go to each of my grandchildren, and the rest of the money gets split among my children. Whatever you want to do. If you happen to be a bit older and you're worried about long-term care planning, like not paying money to the nursing home, maybe you want to put the house in the kids' names now, or put that house in an irrevocable trust that leaves it to the kids and the grandkids when you're gone. But there's a 5-year look back, but if you're healthy enough, get the clock ticking now. It all depends on what your goal is, whether you're comfortable giving something away now that you can't get, or whether you're just going to let it go to the kids and the grandkids when you pass away. But by putting it into the trust now, you do avoid probate, you might avoid taxes. It's much easier and simpler to settle an estate with a trust than it is with a will, especially when you might give money to the grandkids, because in that trust or that will, you might say, the money that goes to my grandkids, I want that money to go to a 529 plan. So you can direct it into a 529 plan so that the kids don't get it when they're 18.
Yeah. Can you see there's another question from Anonymous about the difference between terms of estate tax between a revocable and irrevocable trust?
I don't see the question, but I'll answer it.
You can do that because I can't.
An irrevocable trust is just what it is. It's irrevocable, it's irreversible, it's in stone. You can't change it, you can't amend it. Now, there are exceptions to everything I say, but in most cases, it's done. And in most cases, when you set up an irrevocable trust, you're getting the money out of your estate. And you're doing that for estate tax purposes and maybe Medicaid purposes, long-term care planning at the same time. And if you've given up all control of that asset, it's out of your estate. So when you die, it won't be included as an asset. If it's a revocable trust, revocable means you can amend it, change it, alter it at any time. And your trust is basically just your alter ego. And if you put assets in that trust, they will be includable in your estate when you die, unless you take them out of the trust and give them away before you die. So revocable means you have control of it, but it's going to be taxable. If you're in a state like Florida, it doesn't have an estate tax, and you don't have $11 million, you don't need an irrevocable trust for tax purposes, but you might want an irrevocable trust for long-term care planning. Did that answer the question?
Are there any other questions? I'm looking in the chat. We will, I don't think there are any other questions, but just so everyone knows, we are going to send an email out to all the participants with Mr. Darling's information, with his presentation. We will, if you have more questions that we didn't answer, you can email them to us and we'll answer them for you. And we'd love your feedback on how this was. We gave him a huge task to cover a lot of information, a lot of different age groups. And trust me when I say I didn't pay him to make all those plugs for the American College of Greece, because he did this for free. So we're very grateful. This is a huge donation and a huge value to our community, and we really appreciate it. So
just, when you said I teach a course to lawyers, and it's a whole semester course on everything we just did in an hour. So that's how much information I didn't present. I mean, yeah, it's 2 hour, it's 2-hour course for 13 weeks, and you got it all in a nutshell in an hour.
Yes. So we have two more quick questions, and
Sure.
if they're too long, we can wrap it up and, get back to you. But I think the point is for everyone, this was, for some of us, it's probably very early on this process and we're realizing how much we have to do. Others, they're at the, farther end of this process. But the other questions were, can you explain the concept of a GRAT trust, G-R-A-T trust?
Okay, a GRAT is a grantor retained annuity trust. And you put money in a GRAT, and this is a wonderful time to use GRATs, because you put, let's say you put $100,000 in a GRAT, which would probably be the minimum that you would use. And you put that money in the trust and you pick a period of time. And at the period of time that is going on, you get the income from that trust. At the end of the term, you might get your money back, but any money that appreciated in that trust will go to your children. So you can, when the market's going up and the interest rates are low, you can put money in a trust, have very little income coming to you, and you get a big appreciation because all the capital gains goes out to the kids when the trust terminates. So you want to put something in there that's really going to appreciate. We do that a lot when people have a family-owned business and we think they might be selling it for more than they think it's really worth now, or an apartment building or shares of stock. I mean, a great thing to put in there 10 years ago would have been Apple stock, because it didn't pay much income, but all that appreciation escaping in your estate. You would probably only do that if you had a federally taxable estate, maybe some state tax, but there's other things that you can do. I see another question on here that I can answer too. What are a CRT and a CLT? A CRT is a charitable remainder trust. A CLT is a charitable lead trust. Let me explain that. Again, this is not a paid announcement. The charitable remainder trust is one that you would put, let's say you put $100,000 in it while you're alive, and you would put something in there like appreciated stock that's gone up in value. And if you sell it, you're going to pay a lot of income tax on it. By putting that in the trust then sells it, and the trust is a charitable trust, so it doesn't pay the income tax. But you reserve the right to get, for the sake of argument, 5%. So you get 5% a year out of that trust, let's say for 20 years. Okay, at the end of 20 years, whatever's left in that trust goes to the charity. But when you funded it now with that 100,000, you got a big charitable deduction off your income tax return by putting money in the trust now. So you put the money in, you gave the money away, but you reserve the right to the income. So as this is something you would do if you could afford to part with $100,000, but you didn't want to give up the income. So you put the money in there, you reserve the right to the income. If you find you don't need the income, you can let the charity keep that income for that year, and you get another charitable deduction for that year's worth of the income. The reverse of that is a lead trust. And the most famous was the Jackie Onassis Lead Trust. And the acronym is JOLT. Okay, Jackie Onassis Lead Trust. Now we know that Jackie Onassis had a ton of money from her first husband and her second husband. There was just gobs and gobs of money that she didn't need. And she had two kids that had tons of money. So she put money into a lead trust. The lead trust was one where she put the money in the trust now, and the charity gets the income for a period of time because the kids didn't need the money. So the charity got the income for a period of time. At the end of the lead trust, let's say 20 years, whatever's left in that trust goes to the kids tax-free. In the meantime, when she funded that trust, the value of the income stream for 20 years is a charitable deduction that she writes off on her income tax return. So it's a win-win situation. Those are great. I love doing those.
Great, well, thank you.
I get excited doing it.
Yeah, well, and we hope people want to do them for us, but we are not experts at this. So the big advice I think here, right, is to find, to talk to your financial planner, talk to a lawyer, all of that, right?
Absolutely. Yeah. It's a team approach.
Yeah.
And the advancement department can be part of that team too.
Yeah. So the last question, and then we're going to wrap, and we will send you guys information, and thank you all for joining us, is, are there other states like Florida, no tax, no state tax, no whatever, and it's sure not Massachusetts, and it's not Minnesota, and it's not New York. It is like, what, Arizona, South Dakota, Nevada?
New Hampshire, Texas, California has no estate tax, but they have a very high income tax. Washington and Oregon are not good. Florida, I think South Carolina is pretty good. I'd have to look at my chart. I just don't remember, but where I live in the Northeast, I want people to move north to New Hampshire or south to Florida. Those are the two best states. No income tax, no estate tax. But if you want, I can get you the chart and the list of them, and you can, distribute that. That's public knowledge. That's easy.
Okay. South Dakota, Tennessee, it looks like, question.
Don't know.
I think South Dakota doesn't have, they have very low tax, but they have tax. I mean, in terms of a state.
Yeah, but remember, you have to live there. You can't just go there for a month or two. You got to be there for 6 months and a day to make it your real residence. Yeah,
it's complicated. All right, so I said that was the last question, but we will answer more and we'll send out your information. And as much as, now remember people, this was a huge donation to us. So I don't know how much more free information you want to give out, but thank you very much. So
I will answer your questions that they send for some period of time. Okay.
Yeah, for some period of time. We'll connect you, and
no worries.
And everyone's come from different states and Greece, etc. So I think for most of us, it was just a real good primer. But thank you so much.
One more pitch?
Yeah.
Okay. I was president of the National Academy of Elder Law Attorneys. So I visited 26 states while I was president. So I know all the good lawyers in every state. So if you don't know a lawyer in some state, I'm happy to give you some references also. But you can go on the website. You can go on the National Academy of Elder Law Attorneys website, and you can say, find me a good lawyer in my city, and the computer will tell you who to go to. But I know who they are.
Well, that's a huge, huge gift. Just that, getting good advice, because U.S. is, every state is so different. So, all right. Well, thank you very much. And so we're going to wrap. And like I said, we will follow up with everyone on the webinar. We'd love your feedback of, if we should do another one of these. And tomorrow we have another webinar on mindfulness. So after all this stress about taxes and dying, it might be a good thing to join us for our mindfulness webinar with our Pierce and Dury alumna, Dr. Phaedra Logothetti. And so let's all go meditate tomorrow. So thank you, everyone. Thank you for my team in Athens who stayed up really late. We're really grateful. Thank you, Mr. Darling.
My pleasure. Thank you for inviting me.
All right.
Good night.
Good night.
Or good morning.
Or good morning, exactly.